resolution to two of the hostage situations, so urge all of you to check the news for updates. But we wanted to acknowledge that and let everybody know that we've been thinking about the terrorist attacks, the horrific attacks in Paris. Today, as Greg mentioned, what we want to do is give you a snapshot of issues that are relevant to Canadian AML practitioners. Our conference, by the way, that we're only beginning to prepare for, so there's a lot of opportunity to mold the content, and the topics for that conference will be held June 8th and 9th in Toronto. So for today, we want to give you, again, some topics we've already identified as important to AML practitioners, whether you're in the private and public sector. As Greg mentioned, take your questions, and then, as we said, to begin the process of thinking about how to make sure the program in June is relevant. We also plan to do more regional seminars in Canada. So separately, as you're filling out your evaluations, please feel free to suggest ideas for future programming. We know we have a great group of folks in Canada in the AML field, and you've been tremendous in your support and participation, so we ask you to continue to do that. I'm going to introduce our panelists, and then I'm going to go to Karen Beer for some initial opening comments. We're going to run this as a conversation between these experts. There are slides, as Greg mentioned. These slides are background for you. We're not going to go through each one individually, but this is for your information. We want to try to cover at least 3 or 4 topics today, and we'll see where that goes. And as Greg mentioned, we'll take your questions throughout. I'm pleased today to have with us 3 individuals that have done a tremendous amount of work with the organization, and Karen Beer, our editor-in-chief of ACAMS MoneyLaundering.com. We have Karim Rajwani, who is currently the Vice President and Chief AML Officer for RBC Financial Group. He's responsible for leading their anti-money laundering, anti-terrorism, and client risk management initiatives globally. He has more than 20 years of experience in risk management, compliance, financial accounting experience. He's also a member of the ACAMS Advisory Board. Roz LaRuscia is Associate Director of Operation Compliance at Bank of Montreal. She has nearly 15 years of experience in risk management, internal audit, AML, and corporate compliance in Canada, the U.S., and the EU, and has been a strong supporter of our conferences and a lot of other things that ACAMS has been involved in. Jackie Shinfield is a partner in Blake's law firm, and she focuses on all aspects of regulatory compliance in the retail, financial services, and payments industry. She has extensive experience advising clients on Canada's AML, anti-terrorist financing, and sanctions legislation. And last but not least, Kieran Beer. He's the ACAMS MoneyLaundering.com editor-in-chief with a long career in journalism covering banking, AML, sanctions, and financial crime. Kieran oversees the reporting staff of ACAMS MoneyLaundering.com. And actually, I'm going to start with that and ask Kieran to identify some of the key issues that he and his reporters have covered in the past year, and then we'll get the panelists to weigh in on some of those. And as I mentioned, the slides are background for you, but we do want to cover sanctions, terrorist financing, and related issues. So, Kieran, I'll start with you.
Well, thanks, John. And it's good to be here. And I'm I'm the generalist here. As you say, we cover Canada, and we're really following closely a lot of what's going on. But I'm kind of glad that we have this panel of experts to make clear a lot of the issues that we're looking at. But maybe it's helpful to talk a little bit about some of the things that we are covering on ACAMSMoneyLaundering.com. And some of it is waiting for things to happen, including waiting for OSFI to finalize a risk assessment that is going to have a great impact on how financial institutions do business. We're also looking at tax evasion issues coming out of Canada. OSFI in September, actually at our Vegas conference, we had an OSFI official talk about the need for thematic review of AML controls in offshore banking affiliates and secrecy jurisdictions. And Canada last month moved to, let's say, without going into the details, give special treatment to SAIT KITS, NEVIS passport holders. I think Canada is dealing with a lot of the tax issues that we also cover as happening in the U.S. So we're going to be watching that stuff. I think, too, the thing that really had such a profound effect, we talk about terrorism today, the very dramatic killing in October of Corporal Nathan Cirillo on Parliament Hill has made counterterrorism a very big issue in Canada, and we're watching for how there's a number of bills that are in Parliament that some of which are going to address the larger topic of police arrests, and then also evidence gathering, including bank accounts and what's available. We're going to be watching that and reporting on that. There's two bills that are in front of Parliament that came there before the Parliament Hill incident, and there's now talk about another bill that responds to that incident, and that will give new arrest powers to Canadian law enforcement. So, I say this by way too that we're also looking at how in Canada privacy issues play out against that, and it's a great debate in Canada about how to come up with uniquely Canadian counterterrorism measures. We're also looking at sanctions. Canada has been very aggressive in its Russia sanctions, and at the same time, we're kind of waiting to see, as recently as December 19th, expanding those sanctions. But also, Canada being a little out of step in some respects with Europe and the U.S. in terms of not yet naming some of the big energy concerns, and for whatever reason going on. And that's kind of a debate in Canada, and we're watching that. So, I guess by way of saying what we cover, and this is all things that we have Canadian pages that keep people up to date on what current regulation is coming out of Canada, and also this news. I guess I'd turn it to our panel now of experts, who I think are going to talk about some of these issues, including terrorism. I don't know whether, John, who you want to call on first, but I think that sort of sets the stage a little bit.
Sure. Thanks, Kieran. And to Kieran's point, he named a number of topics. And terrorist financing, Karim, I'm going to go to you in a minute on that. But on some of the other things that he mentioned regarding legislation and kind of the policy, I don't want to say differences, but the policy infrastructure in Canada regarding these issues. All of you have done some work in the U.S. and outside Canada. From your perspectives, what are the primary distinctions between, just from a compliance standpoint, how Canada sees the oversight and governance in the anti-terrorist or the terrorist financing space versus the U.S.? If I could maybe start with that as a quick question, and then I want to go to Karim to talk about what we have some of the slides up here about ISIS, which is obviously front and center, but of course that's not the only terrorist group we have to deal with. So, Roz, maybe I'll go to you first. And obviously you work at an institution that is not simply only in Canada, it's elsewhere. What's the biggest difference for somebody that perhaps is fairly new to AML?
It's with 9/11. When 9/11 hit, I think the U.S. really and truthfully was forefront and did really push the legislation, and they are really ultimately what everybody else looked up to as far as regulatory requirements were concerned. And I would say and what we struggle with here in Canada, I think recently, especially in the past couple of years, there is an emergence of what we see as terrorist acts domestically that we have not witnessed before. And I think from a change in perspective, I think it's going to, what I see on a go-forward basis, I think we're going to find that, and the others can, either add to it or correct me if I'm wrong, but we're going to see that more power assigned to, for example, CSIS agents to be able to detect and track persons that are associated with or suspected to be associated with terrorism in certain groups within Canada. And, so how do we define that? Well, I think it'll probably give them the ability to obtain more information, give them the power to track terrorists overseas or those that are suspected, and is also going to give, I think, the ability and the authorization to share some of that information. and so that's where I see it moving towards, whereas I think that was always the case in the U.S., if that's clear enough.
Right.
I think that it's expanding the powers that didn't necessarily exist before, and I think that, to me, is really and truthfully the way we're moving towards that with the new legislation that's coming into play.
Yeah, I think that makes sense. Jackie, your initial thoughts?
Well, so as a segue exactly to what you talked about earlier in privacy and exactly what was just previously said about terrorist financing, and especially in light of the fact that, we're finding in a lot of situations that people were known to the police and known to the authorities, but because of different rules and regulations in place, not a lot can be done. I see that the one, again, similar distinction between Canada and the U.S. deals with privacy and protection of individuals' privacy rights, even if there is, AML issues. And so we have a real dichotomy between privacy law saying you're only allowed to take what you need and AML law that says KYC, know everything about your customer. And I'd say to date, privacy has been winning for the most part, especially in light of a lot of the privacy guidance out there. But I think you might find that lessening a little bit, and you might find us moving, or I think you likely will in a year from now, we'll be in a little bit of a different environment with what's viewed as permissible to share, what's viewed as permissible to obtain about a person without their consent, what information people can be monitored, searched for, and you're going to find a lot more, I think, pulling on the privacy side to get information that people need to prevent events from occurring as opposed to reacting to them. So I think it's going to be a privacy issue too. You're going to have a lot of civil rights people complaining, but we're going to move closer to the U.S. model because we've now been touched here.
Yeah, thanks, Jackie. We're getting questions in, which we will address, and one of the questions is what we expect from FINTRAC this year. So I'll go to the panel later on that. But Karim, I want to come back to you. We have the first slide that we have up in front is the origins of ISIL's or ISIS's foreign recruits, and I think that's pretty compelling. Where it's so overwhelming. Talk a bit both about that and then some of the other information you've provided, including where the threats are. Who are these groups? And then just from a banker's perspective, what can we be doing?
Sure. I think what we're dealing with right now with ISIL or ISIS is a different threat. Sort of post-Al-Qaeda, this is a post-Al-Qaeda development. Up to then, I think what we were dealing with was terrorist financing. We were looking for dollars, whether those were flowing through charities or other means. So there was a financial audit trail. What we, I think, dealing with right now is a lack of financial audit trails, because this is homegrown terrorism where individuals are flying out to these regions to fight a particular cause. So from a financial perspective, you will see little or no suspicious activity. And it really does require a partnership with law enforcement and intelligence agencies to say, what is it you're looking for, whether those be names or whether those be typologies. One, interesting typology we've been working on with some of the agencies are individuals between certain ages, 18 to 30, that get a line of credit and then fly off to regions. We see a little bit of ATM activities in the bordering countries controlled by ISIL, and then they disappear. So it is a very different threat, we're dealing with compared to the Al-Qaeda.
Let me ask you, I put up here the slide that talks about some of the threats, and you've already mentioned foreign youths and how to, one of the things that you've already talked about is ATM activities. There's some limited ways in which you can do some tracking. But one of the things that jumps out at me is the continued view that MSBs are considered areas of concern. And I know we have a lot of MSB members that really work hard to try to make sure the compliance programs are up to speed, and obviously they have trouble getting banking relationships. So this is another example of trying to balance looking at the threats of, as you mentioned here, Hawalas and other types of MSBs, but also recognizing that they're a legitimate part of the economy. So how do you balance that at your institution? I'll ask Roz to weigh in as well, because it seems to me a tad bit unfair, and no one said life was going to be fair, obviously, but the MSB community is constantly struggling, and this is just another example of areas where they are considered high risk here. You have to be cautious, but then again, how can we make sure that we give them good advice so that perhaps we can bank them?
Sure. Yeah. I mean, like you said, it's not fair, but the reality is, whether we say they're high risk or not, regulators certainly have a perspective on Hawalas and MSBs. From our perspective, our organization's perspective, we make sure they undergo a rigorous due diligence process and external review. So, we've generally been very careful. But that's no different from correspondent banking, so it's not that we're targeting MSBs and saying, well, we're going to put them through an enormous amount of due diligence. But a number of high-risk sectors go through the same level of due diligence before we're going to onboard them. And I think the MSBs that register themselves with FINTRAC that have a compliance program, those are usually less of a concern versus those that don't, right? Because to be an MSB, you can set yourself up in your basement. And it's very easy to set yourself up. Those are the individuals that, are of greater concern.
Right. Jackie, I'm assuming you have some MSB clients, or at least ask from time to time to give advice there. What do you do in those situations, given Karim's point, which is obviously a valid point, that there are a lot of high-risk entities and they have to adjust and obviously show that they, can weather compliance scrutiny? What in this kind of environment, what are you able to tell your clients, and what sort of issues do they still have to manage?
Yeah, well, it's a very difficult issue sitting on this side of the desk when you have a client that you do work for, that you work on their compliance policies, you work on their procedures, you work on their questions ongoing, and then they get a call that the bank wants to shut their account. And as a professional sitting here, that this is a good player. But the problem is not all MSBs are created equally, but they're all painted with the same high-risk brush. And that is a bit of a problem. And, Karim, I'm sure as you could attest to it, a lot of banks just don't want to take any risk. And there's no risk appetite for that at all. So what I do when I'm dealing with MSBs, when I'm dealing with a startup MSB, so someone who's coming to Canada from another jurisdiction or someone who's here starting up, I say we're not even going to go get our banking relationships in place until we have compliance policies, procedures, softwares, systems, and then we're going to go to the bank and say, here we are, here's what we have, here's how our system works, here's our policies, here's our procedures, here's our risk rating, here's our customer base, so that you go as an MSB and you're in a position of being completely prepared, having your CAMLO or your Chief Anti-Money Laundering Officer appointed. They know what they're doing, they know what they're looking for, they can speak to the law, and they understand the law. That's half the battle in terms of starting. From an ongoing relationship, I say you have to manage. You have to manage that when you have audits and the audits go well, and when you have your independent reviews, depending on the client and the banking relationship, we share things with the bank. We talk to the bank. We say, hey, we've identified this issue. Have you? We have dialogue with the bank. If there's any issues with FINTRAC, we advise right away, keep them on top, say this is where we were, this is where we're going, this is what's happening, so that if there is any kind of finding against an MSB that's posted on FINTRAC's website, the bank knew well ahead of time what was going on, how it was fixed, and how it was presented, because by the time these things get posted, the facts that gave rise to them are usually already fixed and done with. So it's really trying to be proactive and just staying on the ball. And a lot of times I'll get calls from people who aren't even clients that say, oh, I have this issue, I'd like you to help me. And they're so far down the track of having had their account shut because they didn't have policies, they didn't have a CAMLO, they hadn't been doing filings, and at that point, to be honest, it's too late. So my advice to MSBs is be prepared, stay on top of it, and be proactive if you do have an issue.
John.
Excellent, Jack. Go ahead, Karim. Excellent. Go ahead.
What I would add is often, MSBs are, have the same challenges as, say, a correspondent bank, right? In that whatever payments they send through us flow through a number of foreign financial institutions. So they're not only judged by the Canadian institution, they're often judged by all the downstream correspondents where that payment flows through. And so, I mean, this isn't just a Canadian issue. It is a global issue where, you know, even if we're okay with it, a downstream correspondent will say we're not in the business of servicing MSBs. And that really does put us in a difficult position in that how do we service our client? The other area I'd say to the MSB industry, and I apologize for generalizing, is the one area where I'd say more needs to be done is around their transaction monitoring and KYC practices. Because often, you know, when we look at it or when we get a question from our correspondents, you scratch your head and say, what is going on?
Thanks, Karim. Roz, anything you want to add to that? And I would just say, as a quick aside before you answer, to our membership out there, we at ACAMS are certainly committed to seeing how much more we can do to help the MSB community, because I think both so far have expressed the frustration, but also recognizing that there are very legitimate, well-meaning institutions out there, and how do we get them to traverse these difficult areas that I know has been going on for just more than recently, at least 10, 15 years. So, Roz, your thoughts?
I was just going to backtrack a little bit to say, you know, unlike, I mean, in many instances, from what I understand, with ISIL or ISIS, they appear to be legitimizing themselves in such places, especially, I would say, Turkey, for example. And by doing so, they formalize their operations by purchasing businesses and running those businesses. And from what I understand, even owning their own banks. And I think it's extremely tricky. I mean, you hear from both Karim as well as Jackie, you know, there are things that you have to look out for, and what are we, you know, it's not, the stigma is not just on the MSBs or the use of hawalas. I think in this case is how do we fine-tune our transaction monitoring in order to pick up what may appear to be legitimate flowing out of such places as Istanbul or Ankara, or even from, you know, some of the other Middle Eastern countries, like Jordan, for example. You know, so we have to rethink, I think, almost what we're looking at, because, you know, it's no longer a $10,000 threshold. It may not be suspicious. So what do we need to do from a financial institution, financial services industry to determine what is suspicious and what's not, when it may no longer look suspicious on the surface? Are we digging enough for the beneficial ownership? Are we asking enough questions? I think sometimes when we get that pushback, you know, we oftentimes stop and we don't go any further. I think we need to push that further.
No, that makes sense. I'm going to shift to sanctions in a moment, but I do want to spend a couple of minutes on this last slide that you folks have provided on managing these risks. We got a couple of questions that came through. One did mention cyber issues, and I think to some degree, Karim, we talk about IP searches here, but could you just briefly go through some of these? So these are ways, you already talked about some of this, to manage terrorist financing risk. And this is obviously not limited to ISIS, but all other terrorist-related groups. But talk a little bit about some of these recommendations here, which obviously are solid recommendations that can help the compliance professional. Again, manage is probably the best way. You're never going to overcome these risks, but perhaps you can mitigate to some degree. But if you could talk a little bit about some of these recommendations here, that'd be great.
Sure. So, you know, the first bullet point, obviously, having that strong relationship with law enforcement and the intelligence agencies is critical. And that's, you know, building that trust and working with them in terms of what are the individuals, you know, who are they looking for? Sometimes they can share, often they can't. But sometimes they can share topologies, and the one I described is one of them where that's something we can do. I think what financial institutions are very good at is scanning their systems, whether they be looking for names or looking for certain patterns of transactions. And this is where I think that relationship with law enforcement is critical. I, train the various intelligence agencies twice a year, and my key message to them and what I try to demonstrate to them is, you give us red flags, topologies. This is what we can do with it. And often I think the intelligence communities really don't understand banking systems, what we can do, don't understand the SWIFT and wire transfer system. And building that relationship certainly has proved to be very fruitful for our organization. As Adverse Media, over the past few years, we've been enhancing our adverse media scanning. And again, I think if I look at 2014, we've had tremendous success simply by going through media and looking for the individuals, and then digging that into the transactional information. And out of that, you may get additional topologies that may be interesting. But at the very least, you'll know whether you've got that individual on your books. And then the last one, again, working with intelligence agencies, this is what we came out with in terms of ISIS or ISIL, is this is the pattern of the highest risk individuals. We don't want to say that these individuals are terrorists, but looking for these individuals, when we did a search, we I think narrowed it down to about 215 individuals, which are high risk individuals.
I want to switch to sanctions, and thanks for that. But I want to ask Kieran a quick question. Kieran, a question came in, but is also, I think, relevant to the previous discussion on terrorist financing. In terms of cyber issues, just in general, cyber hacks, cybersecurity issues, from a standpoint of editorial coverage, what's your sense regarding the AML community's not understanding of cyber threats, because I think they get that, but in terms of who's in charge? My sense is that it's important internally, but it's typically something where AML will partner with the information security side or corporate security, what have you. But in covering cyber issues at all, what's your sense of how far along the AML community is, and maybe some issues they need to be considering?
I think this is still pretty new in the AML community. It's still an issue that we're trying to find ways to cover. It's an issue we're going to address in Hollywood to some degree. I think that the AML, the kind of account and due diligence that's done in terms of monitoring transactions and activity is a tip-off to cyber hacking and trouble. We've certainly seen, lots of these identity theft particularly, interestingly enough, it crops up in community banks, and it often catches them unaware. And I think that really this is just something that, we're turning a lot of attention to, and the AML community is too. So I'm not sure if that answers your question, but I think that this is there's a need for greater coordination, and that I'm not sure AML is leading on that, because it's kind of in tech and in the fraud area, but there needs to be closer cooperation between AML and the tech and the fraud people.
Yeah, I agree with that. And I guess the question for the audience is, as you're filling out your evaluations, there are other places where you can get your cyber content, as it were, in terms of compliance. But if there's areas in which ACAMS can provide some of that content, we obviously are interested in your thoughts, because I think, to Kieran's point, it tends to be in other parts of the institution, but it's becoming more and more prevalent. And so, again, just to be relevant to help with compliance and enforcement and that sort of thing. So let's shift gears and talk about
John?
the Russian sanction. Yeah, sure.
Can I just
Go
make
ahead.
one pitch that people, we've gone past it. Kareem was going to talk about that people look at those red flags on for terror activity, and some of them are really fascinating and interesting, and we don't have to dwell any more on them, but I think that for everybody out there in AML to go back and look at those, including like the dormancy, which shows someone's gone off for training, and we've written extensively about that, and we've certainly had at our conferences, this is an ongoing topic. So I would just, when people get a chance and download them, they should go back and look at some of those red flags.
Right, excellent point. And another quick aside, with the attacks in Paris the other day, one of our members, Dennis Lormel, who I think many of you know, the former head of TFOS at the FBI, prepared a very quick article in response to that from a financial standpoint. So it is up on our site, and Kieran and I both have sent that out via Twitter as well. So take a look at that when you get a chance. The sanctions issue, I think Kieran set the stage for this up front. I want to go initially to Jackie and then to Raz and Karim as well. Give us a sense of the sanctions infrastructure in Canada, and we have some slides here on the different economic measures and the schedule 1, 2, and 3 and that. So Jackie, can you walk us through some of this and give us a sense of the practical of what these things mean to the compliance officer, these definitions here, and maybe some recommendations that you have.
Okay, so the slides specifically deal with Russia because that seems to be the most topical in my practice, and I never really thought about Canada's trade with Russia, but after having so many sanctions that we deal with here, I can tell you this is the one. It's outweighed Iran in the number of questions, inquiries. I'd say at least weekly we have something. So clearly there's a lot of interaction between Canada and Russia. For background, for people who aren't necessarily Canadian or don't understand how the Canadian system works, we are members of UN in Canada as you are in the States. So therefore, whenever the UN passes any resolution sanctioning a country or individual, we pass the exact same sanctions. So we have the same sanctions as the U.S. does in respect of the UN. In addition to that, there are times when Canada feels that the UN sanctions either do not go far enough or do not cover countries that Canada thinks there should be sanctions against for public policy reasons. And when you have that particular issue, you're not under the United Nations sanctions anymore. You're under sanctions that we call them affectionately CEMA, the Special Economic Measures Act. And under that legislation, the Canadian government passes sanctions that specifically deal with other countries that aren't caught by the UN. So that's another set of sanctions. And the Russian there's Russian and Ukraine regulations that specifically come under CEMA. In addition to CEMA, the one other sanction we have deals with Cuba. Hopefully this whole thing will go away if Cuba and the U.S. can get their relations straightened out and they can repeal all the Cuban legislation that's under OFAC and in the U.S. But because the Canadian government does not have sanctions against Cuba, and because of the extraterritorial reach of the U.S.-Cuban sanctions, the Canadian government has passed law that says, hey, if you're a Canadian company, we don't care if you're U.S. controlled. It is prohibited for you to not deal with a Cuban because your American parent tells you, in essence. So, I mean, that's sort of beyond the scope of what we're talking about, but that's a real complex situation that I have on my desk constantly. So, by way of background, the reason I gave that background is that if you were searching the OFAC list, that is not sufficient because the OFAC list and the Canadian list, while they are very similar, they are not the same. We don't have Cuban nationals on our list, and we have more under the Special Economic Measures Act than you do under OFAC, and we don't have known drug traffickers and narcotics dealers under our legislation. So that's sort of a background in terms of how our sanctions legislation works. The sanctions legislation generally applies to any Canadian and any person in Canada. So that is relevant for two reasons. Obviously, if you're in Canada, you know that. But if you are a bank in Canada and you have Canadian employees around the world that are dealing with financial transactions and the like with countries that are not sanctioned under the laws of where that individual is working, they are a Canadian and they are still subject to sanctions. And so that's something that we come across all the time that you have to deal with and you have to be careful with. Now, obviously, a Canadian organization that has its mothership here is going to likely be doing sanction screening globally and probably implementing similar standards. But important to note that if you have Canadian employees and they're in other countries where there's sanctions, you have to be cognizant of that, or your employees will be offside of the sanctions legislation. So something really important to keep in mind for compliance, not just from a customer perspective, but from a staff and employee perspective. Some of our sanctions require reporting to regulators, like OSFI if you are OSFI regulated, the Ontario Securities Commission if you're a securities dealer, and sometimes to CSIS and RCMP or both. If you have a hit on terrorist financing under the UN legislation, you also have to do a terrorist financing report to FINTRAC. So depending on the statute that you're dealing with and where your hit is, you have to research to determine who you have to report to. In terms of Russia in general and the Russian sanctions, the reason that I brought those here is they are very complex and they are not very well drafted. They have divided into, as of December 19th, 4 different groups. The first group are people you just cannot deal with, period. And the second and third group are people who are related to the first group, but there's no prohibition on dealing with them. There's just a prohibition on dealing with either new debt or new equity issued by those entities. And the problem is that the legislation literally uses the word new. What does new debt mean? So obviously, if you're entering into a loan agreement with someone who is a listed person, that's new debt. But what if someone has a loan agreement with this entity that they entered into before the sanctions, and then you want to take a participation, or you're asked to take an assignment, or you're asked to give an LC to support that? Is that new debt? Not clear. Same thing with new equity. You know, when someone issues new shares, pretty easy to tell that they're new shares. But unless you have different classes of shares, if an entity that's listed has common shares issued, how do you know if they were new shares or they're shares in the secondary market? Really hard to trace. And so what we find ourselves advising is, you know, out of an abundance of caution, you shouldn't be touching any of these things because you don't know if you're clear or not. And it's we're finding that the risk tolerance of institutions, you know, like we'll do analysis. We've done 10-page memos and we conclude, yes, you can deal with this person. But we find that by the time we give the institution our analysis of why we think you can deal with this person, because it was a 10-page analysis to do all these reasoning, they're like, you know what, we're not taking the risk. So we find that there are a lot of institutions that, while the sanctions may not prohibit specifically dealing with, by way of example, Schedule 2 and 3 people, they don't want to take the risks. They don't want to go through the analysis, and they don't want to go through their risk team. They don't want to explain, well, it's not indirectly here, but directly there. So these sanctions, because they're so complex, they are crossing our desk all the time. And the last thing I'll say about the sanctions is the requirements to report under these sanctions talk about when you're dealing or you have possession of property of someone directly or indirectly, specifically that's sanctioned, and so that's usually a Schedule 1 person. The problem is because it uses the word directly or indirectly, it seems to require reporting of Schedule 2 and 3 people. So while you're not out and out prohibited from dealing with Schedule 2 and 3 people, except for new debt and new equity, you actually technically have to report if you're in possession of any property of Schedule 2 or 3 people. So it's incredibly complicated. It's not very clear, and I can tell you based on previous experience, if you reach out to Foreign Affairs, their turnaround time is anywhere from 9 months to a year. So you don't get a lot of comfort there, and that's why people tend to be more conservative. So that was
Jackie,
I apologize.
No, that's all right. That's all right. Now that you've made everybody's head hurt, because it's so hard to figure out. Yeah. A couple of questions came in, and I think you alluded to this being unclear, but let me just read these to you if that's okay. One is on the beneficial ownership reference. The question is, regarding beneficial ownership, which are required to be screened for sanctions, what efforts must be made to identify the beneficial ownership of private entities? The questioner goes on to say that the proposed FinCEN rule in the States appears to allow an attestation from the customer. However, the FINTRAC guidance lists sources to obtain this information, but doesn't explicitly allow for an attestation. I think I know what your answer is going to be. So the question is an attestation from your perspective okay to meet the verification requirements in the Canadian regs?
So that's a really good question, and I've been asked that before, and this is where I've come up with. And if you go to FINTRAC, they'll basically say that's for you to determine, just so you know.
Right.
And the things that FINTRAC lists in its guideline as appropriate to determine beneficial ownership don't always work. So by way of example, a shareholders agreement is great, but articles of incorporation do not tell you who a beneficial owner is. So the question becomes, how can you be certain of beneficial ownership of private companies when there's no public record? So what I've come up with, and the advice that I'm giving my clients is, if you are dealing with a plain vanilla, low-risk company, so Jackie Shinfield has incorporated Jackie Shinfield Sweaters, and she's 100% ownership, then in those circumstances, it's reasonable to take an attestation from Jackie Shinfield together with a copy of the shareholders' ledger of her minute book showing that she's the sole beneficial owner of the shares of the company. And if she has a low-risk business and a low-risk company, I think an attestation would be viewed as taking reasonable measures. However, if you have a client that is a higher risk client, or it has an ownership structure such that it is incredibly complicated to trace who the beneficial owner is, you have trusts, and I've seen this, you have layering, you have companies, you have foreign entities, and it's very, very difficult and complicated, and it makes the company a higher risk company. In those situations, I have said that the only way I think you can get reasonably comfortable as to who beneficial owners are is to get a legal opinion or an accounting opinion, because the lawyers at least can review all the minute books and say this is who owns, give you a corporate chart, and an accounting firm will know that as well because they're filing tax returns and there's attribution and they have to know who owns what. So I've done it on the basis of the risk rating of your customer. Lower risk, attestation is okay. Medium risk, maybe attestation together with certified copies of directors' resolutions and shareholders' ledger, and then higher risk, accounting or legal opinions.
Well, thanks, Jackie. I appreciate all that, and I'm sure our audience does as well. Roz, anything you want to add on sanctions? Obviously, there's a lot here. I find it interesting because we have the same issue to some degree with OFAC, where when you ask OFAC about compliance, they just say don't violate the law. So there's not a lot of direction, and it sounds like the direction here is pretty much left to the practitioner and the institution. But anything else from a practical standpoint you want to remind the audience regarding sanctions?
I think Jackie pretty much summed it up, and I'm a little bit removed from the sanctions arena, so to speak. But all I'd like to add is, with the December updates, December 19th, I believe it was, supposedly there was supposed to be some clarification. Is it clear? Well, per Jackie, it's really, I'm sorry to put words in your mouth, Jackie, it's clear as mud.
Yeah,
I think
exactly.
that, it's... They're trying to align it a little bit more to U.S. and EU with the criticism of not doing enough as far as oil, the shipment of certain goods to Russia from an Arctic or a shale oil exploration and production. So they did do those updates, and that's moving towards that. But from a clarification perspective, I don't envy the people that do this on a day-to-day basis on trying to figure this out, because it is very complex. And then you add into the mix the, it's no longer just asset freezes and targeted individuals and entities. You're now talking about, equity financing prohibitions and certifications and energy contracts. So they've almost escalated it and then, again, muddied the waters, and I think it's very, very confusing. So that's
Karim, I want to ask you, we have about 15 minutes left. We've got some questions coming in about some other topics, but one of the things that's being looked at by FINTRAC has been I believe that maybe it's OSFI, the risk assessment issue. Do you want to give us a status update on risk assessment in Canada? I know there's drafts out there, so not asking you to comment on any of those that may or may not get in private sector input, but what the practitioner can expect at some point in 2015 regarding risk assessment?
Sure, yeah. As most people, I think, will know, OSFI does have a guideline, be it on money laundering and terrorist financing. and that has a big section on risk assessments, and I think probably 2015 we'll see an updated version of that. But I think what you're referring to is FINTRAC is planning to publish more guidance on risk assessments, and a lot of that shouldn't be new to the practitioners. You know, it is what we see in the industry, what we see globally. There are, a few areas that are new, and we're, trying to work through what those mean. For example, setting a risk tolerance. We've seen what happens in the industry, when you start talking about risk tolerance and the downstream impacts of that. But overall, I'd say, 80-20, 80% of it or 90% of it you should already have in place. And remember, this is a guideline by FINTRAC. It is really meant to help institutions design their risk assessment programs and really not meant to be regulation on this is how you should do it.
I appreciate that. And obviously, when that gets published, if it's prior to the Toronto conference, we'll certainly have folks commenting on that and getting input from the audience as well. Kieran, I want to switch to you.
Oh.
Yeah, Kieran, I was actually going to go to you.
Too.
Yeah, before you do that, let me ask you, after you ask your question, can you weigh in on, in Canada, how are they treating the virtual currency challenges? Because that's another question that came in. But go ahead and ask your question first.
Well, I think I was going to talk a little bit about, or ask a little bit about, we talked about the murkiness of the Canadian sanctions regime, and it's equally murky here by some estimations. I think one of the differences is when we look at the U.S. regulators is penalties. There just really isn't this history of handing out penalties over sanctions the way there is in the U.S. And, we were even talking earlier about MSBs and cautions about MSBs, and, MSBs really were last year the only bodies that got penalties from FINTRAC. So I guess I was kind of wondering for Jackie if she sees with the rise of the importance of sanctions against Russia and this effort to be, part of the EU and a U.S. effort on this, will we see penalties for violations?
So one of the differences between Canada and U.S. and OFAC specifically is that in OFAC, when you are dealing with someone who's sanctioned, it's a strict liability offense. So there's no defense. It's like if you did, you did, and it's all over. In Canada, the regime is a little bit more user-friendly in that way. The words used in the legislation are things like knowingly and willfully. So there has to be a specific intention on the part of an institution to be dealing with someone who's sanctioned and hiding it and trying to do so because there's a profit being made, sort of thing. And under the Special Economic Measures Act, I think you need leave of the Attorney General to even bring an action. So the standard is a much, much higher action. So if you have a compliance policy, if you have procedures, if you do screening and you do scrubbing and you ask the right questions and you inadvertently happen to be doing something that breaches the legislation, because these are criminal type sanctions, it's a pretty high standard that has to be proved to have a fine or penalty. So to date, when you look at the type of sanctions penalties that are out there, they're really blatant cases where people were sending parts for bombs to Iran and changing the routing of it so it didn't look like it was going through Iran, and changing what the courier package said the contents were. So it's a pretty high standard, and in my view, you'll see penalties if there is a blatant disregard for the law or if someone is willfully negligent. But generally speaking, most institutions in Canada do have decent screening and sanctions protocols that I don't know if you'll see that in the same way.
Hey, Kieran, one of our audience members just sent us a note that in October an oil company was charged with a sanctions violation of about $90,000, and it appeared in the Calgary Herald, so there was at least one example
Yeah,
of a
no,
pretty
no.
high
I believe
fine.
there's been one under that was brought under the Special Economic Measures Act. That's the one they're referring to. Is that's the one with the V rings or that were being sent to Iran?
The one. That's right. That's
Yeah.
right. Yeah. So
But that wasn't
a
financial institution. It was a smuggling. Anyway.
Correct. So I'm saying it's a pretty high standard. You have to either have been completely negligent or just willfully blind or blatantly disregarded. It's a higher standard.
This was a company that argued in its defense that the shipping label was mixed up, that they hadn't really meant to send them to Iran.
Yeah.
So Karen, since we have 10 minutes, what I'd like you to do is just give us your thoughts on virtual currency as an issue in Canada. It comes up obviously from time to time there for all AML professionals, but what are your folks seeing?
Well, I was hoping to escape answering this one, John. You see how much I obfuscated.
I got you, though. I got you.
You do. You got me. Well, I think it's been interesting to see that there has been a lot of talk in Canada. Canada has wanted to, and you hear a little bit of this in the UK, be a leader in virtual currency. And I know that for that to happen, we're still waiting for regulations. And I guess I might defer to our panel to tell me where those regulations are, specifically about virtual currency and how it's going to be overseen in Canada. And I also, the only other thing that I would say is that maybe some of that talk is there are wild libertarians on all sides of all borders who keep talking about the rise of Bitcoin and the potential for other virtual currencies. But I noticed we've just had another Mt. Gox style failure this week. That in which coins have been hacked and disappeared. So I think there's still some questions about at least I've always made the distinction between people who want to be able to use the technology that is associated with Bitcoin for payment systems, how valuable that could be, as opposed to perhaps actually what the future of Bitcoin is. And I have some skepticism about that, but I guess maybe somebody else on the panel can tell me or can talk a little bit about where those regulations stand for virtual currency.
What might be useful here, Karim, I'm going to go to you first, if you could answer that, but also just in general, what are practitioners like you and Roz and Jackie seeing in terms of your agencies for 2015, besides what we already talked about, the risk assessment guidance and some of the other items? What else could we expect potentially, public pronouncements of any kind from OSFI and FINTRAC? If you can give us kind of a preview of what your staff is looking at to keep you guys current with all of that, in addition to answering Kieran's question, that'd be great.
Sure. I don't know the exact status of the regulations. I don't think it's too far away. The proposal is to treat them as MSBs and go through the same process as an MSB. But from a practitioner perspective, we really do struggle with virtual currencies, whether they be Bitcoin or others. Right now, our policy is we will not onboard them because we don't know where we stand with them, whether they're an MSB or something else. We know that they're high risk. It's a emerging area. I think we're all struggling with what do we do with them. How do you bank a institution that or an organization that deals in virtual? What is? We don't even know what the risks are. What the risks are to the customers. So be honest and transparent. It's something I think we're struggling with.
What about in general? What else to potentially expect? Maybe I'll come back to you on that, Craig. Roz, what are you guys looking for? And then just give our folks a preview.
So what I can say is I know in the fall, I know going back with FINTRAC, they don't really necessarily see Bitcoin exchanges as an MSB because they don't remit or transfer funds as a principal activity. And so this is as far as I understand. And from what I also gather, that there has been a strong effort recently anyway, to try and reform across Canada its payment system. So we have the Payment Clearing and Settlement Act. I know we have some work being done on the Payment Card Network Act, and there's also a task force that has been put together. And I think this has been discussed in the last ACAMS conference that we had here in Canada, that with the new payment systems that are offered by Bitcoin, that it's going to move Canada into I hate to use this phrase, but into the digital age, so to speak. And so I know that there is a lot of effort. There's a task force. There's a government of Canada working towards bringing everything together and then finalizing it with the regulations. And the funny thing, unlike the U.S., you see, especially recently, a lot of news, and maybe Kieran can speak to this a little bit. I know that there's a lot of news with regards to the regulations and some of the pushback that you see coming forward from the different regulators, state level and federal. So right now I haven't really heard a whole lot since I would say the late fall, October, November of 2014 to date. So that's all I really have to say about Bitcoin there.
All right, great. Jackie, we have a couple minutes left. Any last-minute takeaways you want to make sure everybody thinks about in terms of compliance, or maybe something that should be on their radar for 2015 and maybe perhaps is not?
Well, that's a good question. I guess the one thing I would raise for people's radar that almost goes back to what Kareem was saying about terrorist financing and organizations is there's been an amendment to the Proceeds of Crime. It's been around for a while now, dealing with directives and the ability of a minister to issue a directive in respect of a particular jurisdiction if it has a concern. And those directive powers are very broad. So they can require reporting of any EFT amount, electronic funds transfer amount, cross-border. If someone picks a jurisdiction, and let's say Syria, just for argument's sake, anything to Syria could be reportable, whether it's $1 or $10,000, and right now only $10,000 are reportable. So they can pick any jurisdiction and put different requirements for beneficial ownership, make that be drilled down at the 5% level, make ID be verified at a $0 level. Like, there's all kinds of abilities by passing these directives to have specific requirements where monies are going to certain jurisdictions. And I think with what we're seeing with ISIS and everything, that might be the power that the government uses to get what it needs without re-amending the legislation. It'll just pass a directive saying, okay, any money transfer going to this jurisdiction, you have to verify the identity of everyone. Any corporations, 5% beneficial ownership. Anything that's sent has to be reported. So that's where I think you might see some movement vis-a-vis to deal with terrorist financing issues.
Great. Thanks, Jackie. Kareem, I'll give you the last word. 30 seconds. Anything you want the audience to make sure they're paying attention to in 2015 that we haven't talked about or you want to echo?
Sure. Very quickly, domestic PEPS is coming in 2015. There are also, regulations. Changing the regulations around customer identification, authorized signers, definition of a signature, and prepaid access cards. So, we'll expect to see regulations around all of those topics.
Excellent. I want to thank Kieran, Kareem, Roz, and Jackie for their time today. I know it was short. I know we weren't able to get into all the issues, and your questions are very valuable in helping us steer future programming. We'll do another webinar on Canadian content as well as the Toronto conference. So as you're filling out those evaluations, please let us know what else would make sense for the practitioners, whether you're in the private or public sector. Again, the Canadian audience is so important to us. We have over 1,000 members in Canada, so we thank you so much for your loyalty and support of the organization, and thanks for your time today, and I'm going to turn it back to Greg.
Thanks, John, and I can honestly say that from the comments, you obviously hit a strong vein with the audience, very engaged. That'll be it for now from Miami. I'm Greg Fields. If you have any other questions, consider sending them to training@acams.org. And here are some future web seminars to keep in the back of your mind as well. Thank you for joining us, everyone, and we'll see you soon.